Hi, and welcome to Hull & Hull TV. I'm Suzana Popovic-Montag, the managing partner of Hull & Hull, a firm that specializes exclusively in estate, trust, and capacity litigation. Here at Hull & Hull TV, we explore estate and planning issues as they may affect you. And today we're pleased to be returning to part 2 of our contentious issues in estates series, mini-series as it may be. And we're joined by Jordan Atin, who's counsel to our firm, and Ian Hull, who is the co-founding partner. Welcome, gentlemen.
Thank you.
So we're just going to follow up on our discussions on our first part of this series where we talked a little bit about the litigation steps and the materials filed when you're dealing with power of attorney litigation. And I thought we might just introduce the concept or introduce this program by developing the law in this area a little bit.
Right. Well, powers of attorney fights, let's look at it from a guardianship point of view, because that's usually how you get before a judge. You've got a situation where the person is alleged to be incapable, and now you're fighting over who's going to be in charge. So a court has to find the person incapable, and it's a dramatic finding because you are taking away the rights of a person. As opposed to a power of attorney gives rights, so it's saying, I'm going to allow you to make decisions as well as myself on financial matters. Guardianship's different. A guardianship takes away the rights of the incapable person and plants them with one person. And so there's that dramatic finding of incapacity, which is usually based on assessments by either assessors or doctors, and that's the first step to a guardianship matter from a legal point of view.
Ian, do you have anything to add to that?
Yeah, well, these fights, anything contentious in this area, and certainly in Ontario and across the provinces, they have their own provincial statutes, but are governed by the Substitute Decisions Act. And it is one of those rare acts that is relatively helpful. It doesn't hurt that it was brought in 1994 and amended slightly after that. And it gives us very specific parameters of determining questions of incapacity, and which of course helps the judge. So that the judge has a framework to take all of this medical evidence and some of these assessments and so on and assess in his or her own mind whether or not capacity is a finding that they can or cannot make. So if we go to the core elements of the Act, which are early on in the Act in terms of the definition of incapacity, we then also can go to the Act for its specific steps procedurally, and that is combined with some of the rules of our court as well. But the procedural steps are also identified in a guardianship fight. So for those of us who do this work, we're at least blessed with a fairly straightforward set of parameters to get the fight going. The challenge in all of these cases is that everyone is so different than the next, and everyone's cognition is so different than the last one, and no judge can sort of cookie cutter cognition and strength of cognition, undue influence, and all of those things.
And I expect there's a very big emotional component to this kind of litigation too that you may not see necessarily in other kinds of estate litigation.
For sure. I mean, don't forget that the person that we're fighting about is right there. It's like a custody battle with kids, right? I mean, you're fighting, sometimes it's fighting over who's going to control the money. Those are in a sense a little bit easier. What about decisions about where mom's going to live in a retirement home, or, you know, end of life decisions? I mean, how do you can't imagine the emotion that's involved in there. And that's what makes these among the most difficult to litigate.
And I think for judges as well, too.
Well, it certainly is, and I don't envy them in this situation. It is a very tough decision. As Jordan's already identified, they have to make a very dramatic decision as to whether or not they're going to take their individual's liberties away by finding the individual incapable. And second of all, it's not an area of comfort for them. It's not the kind of work you would see regularly in the courts, determining cognition and levels of cognition, and those kinds of legal medical issues are not their comfort zone. And let's be honest, judges are typically over the age of 55 and some up to 75 before they get mandatorily retired. And they're all in this world of either their parents are struggling with these issues or they will be struggling with these issues. And it's a personal issue for many of these judges.
And just maybe in terms of a wrap-up, just some practical tips that we can leave people with?
Well, I mean, do everything you can to avoid these kinds of matters. I mean, mediation, meetings among the family and the caregivers and anybody you can bring into the fold to try to resolve this in an amicable way. Come up with a game plan for, okay, how are we going to manage mom's affairs? Let's document them. What are the decisions that have to be made, and how can we work through that rather than spending spending thousands, tens of thousands, hundreds of thousands of dollars, which is not necessarily going to come out of mom's money. It's going to come out of the kids' money. So do everything you can to try to resolve it, but short of litigation.
Great advice. Thank you very much, Jordan. Thank you, Ian. And thank you for joining us at Hull & Hull TV.